Right. Good evening, everyone. Thank you so much for being here. And I'd just like to start by saying Happy New Year to everyone. Slightly belated, but it's important for us to have a good start in 2026, and I wish you all good health as well. Now, I also like to welcome those who are online today. Thank you for joining us. My name is Gilberto Leung. I'm a neurosurgeon from the Li Ka-shing Faculty of Medicine, and I have the pleasure of serving as the co-director, or one of the two co-directors of the Center for Medical Ethics and Law, which is a joint collaboration, a unit between the Faculty of Medicine and the Faculty of Law. And we have this annual review of Hong Kong health law for quite a number of years, and it's always been well attended. We intend to make it more interactive in nature. We are targeting people who might have no legal background, no training in law. We aim to create opportunities and topics for discussion. Now, we would like to focus on medical law and cases and jurisprudential issues that are relevant to Hong Kong, although we might cite overseas cases, especially those from the UK. Now, tonight we are very, very honored to have three very distinguished speakers. I am just the guy saying hello and concluding remarks. The real star today is number one, Professor Craig Pursehouse, who is the Deputy Director of CMEL. He's from the Faculty of Law, and he will start later. And then after him, we'll have David Khan, who is partner and solicitor advocate of House Williams. He is actually a good guy from the law side because he defends doctors. And also we have Ms. Jane Orr, the research manager of CMEL, who has done a lot of work by preparing the written materials that you can retrieve online by email. So without further ado, I'd like to invite Craig to talk to us about medical negligence, regulation, and also reproduction updates. It's a very wide scope. Please, Craig.
Thank you, and thank you everyone for coming today, and Happy New Year as well. I'm delighted to be here. Can you all hear me okay? Great, so the topics I'm going to be talking about today are medical negligence regulation and reproduction. So there's not really a common theme amongst what I'm going to be talking about today, other than the fact that they are health law cases, but hopefully at least some of them will be of interest to you. And I would say this has been probably a quieter year for health law, but there still have been some very interesting developments. First, I'll talk about a clinical negligence case. This is an overseas decision from England, but the rest of the decisions I'll be talking about today are local. So this first case, even though it is an overseas decision, so it's not binding here in Hong Kong, it still is of interest. These principles may be applying the same way if a similar case came up in Hong Kong, so it is still useful to consider. And this is a very tragic case. The plaintiff in this case is a newborn baby who was subject to physical abuse by his mother. So the plaintiff, Sydney Conway, his mother had abused the child, and he fell ill as a result of these injuries. He was taken to hospital, but because his mother had shown this display of concern, there was no reason to suspect that she had been abusing the child. So the healthcare team weren't expected to know that she'd been abusing the child. The favored diagnosis was pyloric stenosis, and he was admitted to hospital. But really, it was a result of abuse. Consultant ordered an ultrasound test of his abdomen, and this showed no support for this pyloric stenosis diagnosis, and the presenting symptoms had then been resolved. So he was then discharged from hospital back into the care of his mother. The plan was for his head measurements to be kept under review. But the day after he returned home, his mother then assaulted the child again. And this time he suffered catastrophic brain injuries and was left with a series of serious disabilities, developmental delay, neurodisability, visual impairment, and epilepsy. In this case, his father, who brought this litigation on his behalf, alleged that the team treating him, or at least some members of the team treating him, had been negligent in just keeping the head measurements under review. He argued that an ultrasound scan of the head and shoulders should have been performed, not just of the abdomen. And if this had been carried out, he argued that these disabilities would have been avoided. Now, a consultant had actually considered the possibility of an intracranial cause of Sidney's head injury. So one of the consultants had considered this, but the notes just said to perform an ultrasound scan of the abdomen, possibly cranial as well. But the cranial one of the head and shoulders was not carried out. The plaintiff's case was that no reasonable medical practitioner would have adopted this course because the abdominal scan had shown that the initial diagnosis was not the cause of his injury, so this had left a diagnostic gap, and the plaintiff's case was that this meant they should have carried out a scan of the head to find out what was actually wrong. And it wasn't disputed that if this head scan had been carried out, this would have revealed that he'd sustained trauma to the head. This would have then led to further questions about how this head injury was caused, and this would have then deprived the mother of the opportunity to assault him again. So he would have avoided these disabilities. However, this case failed. The judge in this case adopted this 6-stage approach to determining clinical negligence from a UK Supreme Court decision called Khan and Meadows. This approach is different to what is commonly seen as the standard approach to determining medical negligence. Normally, we'd ask, is a duty of care owed? Is that duty breached? Did the defendant fall below the standard expected? And was this breach the cause of an injury that's not too remote? Instead, in Khan and Meadows, the UK Supreme Court adopted a more complicated 6-stage test. I won't go into too much detail, but this 6-stage test attracted quite a bit of criticism when it came out, and in subsequent cases it hasn't always been adopted. So the fact this judge adopted this approach is notable. It might show that the appropriate approach to determining clinical negligence is still in flux. But the reason this case failed was at the scope of the duty stage. So this is the idea that it's not just enough to show that the defendant owed the plaintiff a duty of care. They must also show that this risk of injury fell within the scope of that duty. So here, the duty of the defendants was to take reasonable care in the Bolam or Bolitho sense, so complying with a logical and responsible body of fellow medical opinion, to take reasonable steps to respond to the risk of deterioration which Sidney may have been suffering. the judge said it wasn't to take steps to prevent all and any consequences of being discharged. So put simply, the defendant's duty was to respond to the symptoms they were faced with and prevent any deterioration. It wasn't from that condition, not to prevent any form of harm, however caused. And so it was thought this harm caused by the mother was unrelated to the nature of the duty that the doctors, in this case, owed to Sydney. They decided in this case too that for breach of duty, it was not a breach to fail to perform the ultrasound scan of the head. The reason for this was that the judge preferred the defendant's experts, that just keeping the head measurements under review would have been a reasonable course of action. So it was, but the problem here was the plaintiff's expert witness admitted that Sydney could be discharged without the head scan being performed. So the expert here said he could be discharged as long as a head scan was performed very soon. So here it seems that the plaintiff's expert probably conceded too much here, because if he was allowed to be discharged, but just that a head scan had to be performed very soon, how soon is very soon? If it was 2 days later, and we might say that probably is very soon, it wouldn't have avoided the injury because the mother assaulted him the day after he was discharged. So here this meant that there was a lack of causation as well. So the judge here found there was no breach of the duty. They hadn't suspected any domestic abuse by the mother, so they didn't have to further investigate that line of inquiry. They weren't expected to know that. And given what they did know, keeping their head measurements under review was reasonable. This meant there was no causation, couldn't establish that this, there was no breach and no causation. And also this injury fell outside the scope of the duty. So it failed on numerous grounds. Would this case still have been dismissed under scope of duty, though, if the decision on breach had been different? This is a question we don't have the answer to, but what it does indicate is that there might be an increased role for scope of duty in dismissing medical negligence cases. This is probably quite controversial because scope of duty, it's often arisen in context of professional negligence for purely financial loss. Khan and Meadows itself, where this 6-stage test of analysis was derived from, was a medical negligence case too, but this shows that the judge is heavily dividing the aspects of the doctor's duty, defining it quite narrowly. This could result in more plaintiffs losing their cases if scope of duty takes on this greater role. So that's the first case on medical negligence. The second case is a case of professional regulation. This case, Dr. Leung and the Medical Council of Hong Kong was a case where Dr. Leung was found guilty of professional misconduct and reprimanded by the Medical Council. The reason for this was he had promoted screening for stomach and colorectal cancer at discounted rates. So he had put the original price with slashes through the original price and then a cheaper price. And he'd also included a monthly quota of 10 people for these screenings. Under Section 5 of the Medical Council's Code of Professional Conduct, it prohibits the soliciting or canvassing of patients. Adverts are allowed, but they are subject to quite stringent restrictions. And in this case, the council held that the discount, the limitation by quota, and the crossing out of the original price were promotional tactics. However, they did, in this case, acknowledge that the doctor's transgression wasn't intentional and he was motivated by concern for patients. However, he then appealed this decision to the Hong Kong Court of Appeal and argued this was not a promotional tactic, that the council had failed to properly carry out a balancing exercise, and that the finding was an interference with his constitutional right to freedom of expression. He said that the council should have found that he was entitled to issue these advertisements. This appeal, though, failed. Although the code does not expressly mention that doctors cannot offer discounts, the clear intention of the code, said the Court of Appeal, when read as a whole, was that this is not permitted. The Court of Appeal also said that the council was entitled to conclude that the adverts went beyond mere public education, and they were entitled to see this as a commercial promotion. The constitutional challenge arguing that this was a violation of his right to free speech also failed because the restriction was not disproportionate and a proper balance was said to have been struck here. The reason for this is that the council was said to be entitled to take a zero tolerance approach to threats to public health, and they do not have the resources to regulate all forms of communication. So the council doesn't have the resources to check every medical practitioner's adverts to see whether they have got the balance right or where the line should be drawn. Instead, given their limited resources, they're entitled to take a stricter approach. So this appeal failed, and Dr. Leung applied for permission to appeal to the Court of Final Appeal, but this was denied by the Hong Kong Court of Appeal. So this might be the end of the road with this case. Another interesting case is on to do with mental health and the rights of discharged patients. So in this case of Ha Chi Wei, the applicant had been diagnosed with paranoid schizophrenia and had been detained under a number of provisions of the mental health ordinance at the defendant hospital. So this is the Eastern Psychiatric Observation Unit. He had been conditionally discharged in 2010, and this was subject to a recall of detention and with conditions, as a conditional discharge would indicate. In 2014, he then heard that he had a right to apply for a review of his case. And so after this, made annual applications to the Mental Health Review Tribunal seeking a discharge. 4 of these decisions went against him before the medical superintendent decided to discharge him absolutely in 2020. So he was eventually discharged. Now, he sought judicial review because from 2010 to 2014, he didn't know about his right to seek a review from the tribunal. So he challenged the failures of the respondents to take steps to ensure that he knew of this right. And he argued that this was contrary to legislation, common law, and his constitutional rights to liberty, procedural fairness, and a fair hearing. And the judge in this case said this is a very important issue because if a patient is not aware of their rights, let alone the full extent of them, it could be argued that these rights are practically worthless. So this is considered a very important case on the rights of patients. And his judicial review was successful in part. However, under the mental health ordinance, under section 68A, this contains a duty to give information to detain patients of their rights to apply to tribunal. However, the judge in this case said this did not apply to the applicant. Patients who have been discharged, whether conditionally or absolutely, are not detained. So his argument that this violated section 68A failed because he'd been discharged, he wasn't detained. So the rights of detained patients to be informed of their rights to a review by a tribunal didn't apply to him. His constitutional challenge also failed. Coleman J. held that a conditional discharge might at most amount to a restriction of liberty, but it doesn't indicate a deprivation of liberty, which is stronger. So his right to liberty wasn't violated. However, the judge then held that if section 68 didn't apply to patients who've been conditionally discharged, and then the common law would step in to protect them and provide them or protect their rights to the same extent. So where a patient is subject to a conditional discharge order or is given notice of variation of conditions attached to that order, they should also be told that they have the right to apply for a review to the tribunal. This meant that the current discharge forms require amendment. So here, the common law has filled a gap in the law. However, the judge said that the applicant's submissions that the tribunal should fill this same gap and tell him his rights to a review failed. There was a gap between the hospital and the health authority and the applicant, but fairness between the applicant and the tribunal can be achieved by other means. So this case recognizes a common law right to be informed of your right to a tribunal as a patient subject to conditional discharge. So this is a significant case on the rights to patients, mental health patients. The next updates I'm going to give are on reproduction issues. So the first case is this case of K and Secretary of Justice. So in this case, the child K had been born by reciprocal IVF. I'll explain what that is in a moment, in South Africa to a married same-sex couple. The couple, one of the couple was from South Africa originally, but they were both lived in Hong Kong and were permanent residents of Hong Kong. So Kay's parents were a married same-sex couple, married in South Africa. One of the parents was the genetic mother. So with this IVF, R's eggs had been used to create the embryo that led to K, and B was the gestational mother. So R's eggs were used, donor sperm was used to fertilize the egg, and this was then transferred to B, who carried the pregnancy. So the point of this reciprocal IVF is that with this lesbian couple, one member would, it would be their genetic material, the egg that was used, the other would carry the pregnancy. However, only B, the parent who carried the pregnancy, the gestational mother could be registered as Kay's mother. Kay then the child brought a judicial review challenging the failure of two ordinances, the Parent and Child Ordinance and the Births and Deaths Registration Ordinance, to provide a mechanism for recognising R as Kay's legal parent too. So the forms only allowed a mother and a father. B would be classed as the mother under these ordinances, but B would be classed as the mother, but R would not be classed as a father, and there were no mechanisms for a second legal parent, which some other jurisdictions have. So this was challenged in a previous judgment. The judge had held that R, the genetic mother, could be registered or could not be a parent under the Parent and Child Ordinance, which only recognises mother or father. However, the judge in this case said that R could be a parent at common law based on the fact that R is a genetic, social and psychological parent, and this would be in Kay's best interests. So that was the first case. After that decision, the Department of Justice wrote to R and refused R's request to re-register Kay's birth. And the Department of Justice said parenthood at common law is not a sufficient basis for re-registration. There was then a judicial review challenge before Coleman J, which is the subject of this case. Now, the first issue was this idea that R or one of the parents could be a parent at common law. The judge in this case described this as a consolation prize with no practical legal effect. The problem was, if there is a statute which states that the person is not a parent at all, and that another person is only to be classed as the parent, how can somebody be a parent at common law? And he concluded that the original judgment certainly had no practical effect for any legal purposes and was probably wrong. So the judge in the second case had severe doubts that you could be a parent at common law. He said this had no real practical meaning and was probably just a consolation prize. It didn't itself allow for re-registration. However, there was then a constitutional challenge to this legislation, and Kay's constitutional challenge relied on three sets of rights from Bill of Rights and the Basic Law. These were right to privacy and family, children's rights, and the equality right. And then the judge then assessed whether these rights, which were engaged, whether they were infringed. And in doing so, he said that the birth certificate is a vital document to verify parental authority. And the child here would be seen as only having one parent. And this would be very problematic for the child because it would be inconvenient for the child. It would be embarrassing for the child. As the child became older, he would become aware of this situation, and this would cause him harm, this inconvenience and embarrassment. It would lead to a sense of inferiority, and it could have irreversible prejudicial consequences. Some decisions require an immediate decision, and one of them might be urgent medical treatment where you might need parental consent. The judge thought this would be a situation where this would create significant problems for Kay. Carrying a court order would not be a solution either, saying that the other parent had some rights, nor would guardianship be a solution. That only confers rights and obligations until the child turns 18, whereas parenthood provides legal status and identity for life. And this inaccurate manifestation of the child's identity therefore interfered with the child's private and family life. The judge then undertook what's called a Hyson analysis to identify whether this interference or these intrusive measures could be justified. The Hyson analysis involves considering whether the interference has a legitimate aim, whether there's a rational connection to that aim, whether this interference is doing no more than necessary, and whether a reasonable balance has been struck. And the judge held that this law lacked a legitimate aim and rational connection, and that it was disproportionate. I won't go into all of the arguments, but the judge did dismiss some of them. So, for example, the government argued there should be flexibility in recognizing parenthood for same-sex couples, but the judge said this was a blanket ban and so wasn't therefore flexible. And also heterosexual couples do not have to prove that parenthood is in the child's best interest in the same way. Also, the government had argued that there was no social consensus and that dual motherhood might not be socially acceptable. The judge said this is irrelevant when considering minority rights, and that dual motherhood was a red herring. The consideration here was dual parenthood. And the government also said that unmarried fathers do not automatically gain rights to be registered, but the judge said that's a difference in kind, not degree. They can still be registered, whereas here this law says that same-sex couples can't both be registered. So here the constitutional challenge, other reasons were given and rejected as well, but the constitutional challenge was successful. However, it was held that further argument needed to take place on the appropriate form of the declaration. So it was held the constitutional challenge to these laws was successful, but we will probably need to wait until next year's update to find out how this will be resolved. As a postscript to the judgment, the judge said these comments, which have gained some traction in press and legal blogs, he said that ignoring this might be like King Canute, and we shouldn't bury our head in the sand with these issues. Final update from me, there's the Human Reproductive Technology Licensing Amendment Regulation 2025. This one, quite small update, but gametes and embryos that are being stored, they would generally be stored for no more than 10 years. This regulation amendment now allows them to be potentially stored for longer, allowing people to decide for themselves how long they wish them to be stored for. So they're the updates from me. There's not necessarily a common theme amongst them, but I'm very happy to answer any questions people may have. Thank you.
Our next speaker is, should I call you Dr. David Khan or Mr. David Khan? He was trained as a surgeon, but he defected to the dark side and became a lawyer, defending doctors actually. So now he is a partner of David and Kristen House Williams, and today he's going to talk to us about number one, the mandatory reporting of child abuse ordinance, and data security and the protection of critical infrastructures, computer system ordinance, and recent case authorities on informed consent and Montgomery. A very broad scope again. David, please.
Thanks very much. Before I start, hands up those who are medically qualified, legally qualified. Right, people in numbers then. So, right, anyone here who's a cardiothoracic surgeon? No? Never mind, it will become clear in a minute. I thought I'm loud enough. Right, now I'm loud enough. And for something not completely different, child abuse. There is no pediatrician here, but I have a diploma in pediatrics from this university. In fact, I'm not a specialist. Having said that, those of you who are doctors will agree with me that we are all trained to detect signs of child abuse. Some of those signs are more strongly suspicious of child abuse compared to others, such as certain types of fractures, apparently fracture of the spine, fracture of the posterior ribs. That's quite strongly suggestive of child abuse, whereas other signs are more fuzzy, especially when it comes to emotional abuse. The signs are more subtle. Now, and in fact, the NICE guidelines, December 2025, went as far as saying that there is actually no gold standard in determining emotional abuse. Now, as of now, doctors are encouraged to report abuse. And from the 20th of January 2026, after this ordinance, as you can read, doctors and others, it will become mandatory for them under certain circumstances to report suspected child abuse. Now, I will speak concisely on this topic and the next two topics, so I'll go through the slides quite quickly. Arising out of this ordinance, a guide has been published and it's right here, and it's a guide for to guide practitioners in deciding whether to report suspected cases of serious abuse. Now, there are two ways to look at this guide. On the one hand, I've been through it. It contains a lot of clinical details and is quite prescriptive, telling you, almost overriding your own judgment as to whether you should report. Another way of looking at this is that, well, it helps you. It helps you in forming a clinical judgment as to whether or not you should report. Now, the target, quite simply, are the under 18. In Hong Kong, under 18 are the minors, are the children. And it is important to note it thus is not meant to cover the adult MIPs. This is the most important slide of all the slides in this PowerPoint. Under what circumstances are you meant to report? You're meant to report, I'll say who are you in a minute, when there are reasonable grounds to suspect serious harm, whether ongoing serious harm or there is a risk of future serious harm. Now, pausing there, those of you who are lawyers will ask, what is reasonable ground to suspect? Now, there is no further guidance, as far as I'm aware, on this with the ordinance, although if we look at similar legal circumstances, such as police having reasonable ground to suspect commission of an offense, hence they should arrest. If you look at that, in simple terms, it seems to be both a subjective and an objective test, meaning if we come back to our circumstance, whether that doctor subjectively has ground to suspect serious harm, or that the reasonable doctor, the objective test, should have reasonable ground to suspect. I hope I'm not going too fast. Now, who are these people? Who are the specified professionals? Even you can't focus that far. The blue are the healthcare professionals, so the onus is mainly on the healthcare professionals. The green, the educators, the teachers, less so on the teachers, even less so on the social welfare workers. You don't require parental consent to report, and indeed, it defeats the purpose if the parents are the perpetrators. And beyond that, let me see if I've got the right slide on. I do apologize. Beyond that, here is an interesting situation. What if the child is mentally competent and the child doesn't want you to report? So that's an interesting circumstance, and is asking you not to report. Under the ordinance, the practitioner is meant to advise the child of the purpose for reporting and not to promise confidentiality. Now, in effect, you still have to report, and there is no statutory defense to say that the child asked you not to. That's not a defense. Consultation with the authorities is not the same as reporting. You would expect that. As those of you who are medically trained, you know there are different types of abuse: emotional, physical, sexual, neglectful type of abuse. I mentioned serious harm is one of the considerations, and when it comes to physical type of abuse, the threshold is quite clear and is quite high. So it has to be quite significant injuries before the practitioner, whether doctor, dentist, or other practitioners, healthcare professionals, have the duty before it amounts to a serious harm. The way I read it, when it comes to, I do apologize, this is a bit twitchy. When it comes to psychological type of abuse, the bar to me is much lower, much lower, because as long as there is an act that endangers the psychological health and well-being and development of the child, then that amounts to serious harm. Sexual type of abuse. Right. Let me try again. Sexual type of abuse is quite clearly defined. And when it comes to, I do apologize. I hope I'm not giving you seasickness. When it comes to neglect type of abuse, once again, the bar is quite low. It is whereby the responsible person, so back to James' question, the father would be a responsible person, responsible for providing an environment of safety and to provide necessities for the child. If that fails and endangering the health of the child, once again, very fussy and very low bar, then the practitioner is meant to report. When it comes to exemption, under what circumstances the practitioner doesn't have to report, there are two main ones. The first one, just like the coroner's ordinance, when it comes to notifying reportable death, if you know somebody else has done it, then you don't have to do it. Or a peculiar one for this situation, or if the harm is caused by the child himself or herself, or another child other than for sexual harm. For defenses, there is only one when it comes to delay in reporting. And it is whereby, in a nutshell, where the practitioner, let's say the doctor, feels that he needs to take immediate steps to safeguard the best interest of the child, seek treatments, stabilize the child's emotion, to take her to a safe place away from the perpetrator. Those would be reasons to delay in reporting. But one thing to note, under the statutory defenses, there is nothing to defend you for failure to report. It only applies to delay in reporting. Well, if I'm going to defend a doctor based on failure to report, then I suppose the only way is to show that those requirements, the components on the slide I said is the most important, that there is no reason for the objective doctor to suspect, and it didn't amount to serious harm. I think that's the only way to defend a doctor who omitted to report at all. I will skip through a few slides. You can see that this is a horrendously complicated flow chart. I can guarantee you, if you squint really hard, it still doesn't make sense. When it comes to the form of reporting, it is quite mechanical. Who are you? Why? And who is the child in question? It is still not agreeing with me. When it comes to reporting in emergency situations, you ring 999. Otherwise, you report to either the police or the Family and Child Protection Services Unit of SWD. It is expressly said that by reporting, you do not incur any civil or criminal liability, and it doesn't amount to breach of your professional duty. But I'll bet you some parents will still take you to the medical council. But as long as you have kept good records to show you have justifiable reason to report, we can defend you. As you can imagine, the commission of this offense is punishable by a fine up to $50,000 and 6 months imprisonment, both a fine and the threat of imprisonment. And the doctor is then meant to report to the medical council if he or she is convicted. Now, can I actually try to operate this using my laptop? It may be easier. This really hates me, this remote. No? Okay, let's wait a little bit longer. Practically, you can imagine that there is a risk of over-reporting, and indeed in other countries, introduction of such a law has resulted in over-reporting and potentially strain on the public resources, not to mention mental anguish. I'm not going to try to operate the slides. I will just talk through my only remaining message. As a doctor, at the end of the day, it is exercising clinical judgments. So if in doubt, quite simply talk to your senior colleagues. That happens in medical legal situation very often. And by talking to the senior colleagues, you ensure that it is more likely the resulting decision is defendable and is able to withstand challenge. And the other thing I would suggest, as I always say, keep good records of whether you report or end up not reporting. Keep good records and take extra care when you make records to do with potential child abuse cases, that it is objective. There is a big difference between I see the bruises looking like the bruises from a hand slapping the child compared to the child told me I was slapped and therefore I have the bruises. Easily got wrong. And so keep good records, and that will put you in a good position to defend yourself in the event of a complaint. Now, I would like to move on to, I think we better swap seats with Craig after all. Right. Here again, much easier. Now moving on to informed consent. And our dear friend, Montgomery. As most of you know, the case of Montgomery was a landmark case in 2015 on consent. We medical defense lawyers regard consent as always an important link in defending medical legal proceedings. Now, arising out of Montgomery, at least two principles came up. First, a doctor has the duty to advise his or her patients on material risks of treatment. And by material risk, it is once again both a subjective test and an objective test, meaning what is material to the patients in front of you and what is material to the average patient. The other principle, most important principle arising out of Montgomery is that a doctor also has the duty to advise on alternative treatment options, including the option of no treatment. So there, in 90 seconds, I summarized the case of Montgomery. Now, since the case of Montgomery, there have been many cases that applied or clarified Montgomery, and I'll deal with three of them. The first one is McCulloch. Has anyone read the case of Montgomery? Only, four of us, 5, 6, 7. It's a very readable case. It's not one of those really boring, put you to sleep cases. It's very readable. And if you read Montgomery carefully, you can already see indication of what McCulloch says. Now, what did McCulloch say? In McCulloch, the patient suffered from suspected pericarditis. And the question was whether the treating doctor should have advised the treatment option of NSAIDs, non-steroidal anti-inflammatory drug, which is supposed to help. Now, the doctor didn't in that case. So was he negligent? Arising out of McCulloch, and if you read Montgomery carefully, it already says that in Montgomery. In the case of McCulloch, there are three questions. See if I can put it in the simplest way. In deciding whether the doctor has the duty to advise on certain alternative treatment options. The first point is the doctor, in narrowing down all possible treatment options, possibilities, into only reasonable treatment options. And by the way, I'm saying more than what this slide shows. The doctor is meant to exercise his clinical judgment. And that is determined by the doctor, not by the patient. And as long as the doctor, probably with expert evidence, can show that he exercised his judgment in accordance with a body of thoughts, body of opinion of doctors, which is responsible, then he's not negligent. Now, the second point is then, having narrowed down from all the possibilities to the reasonable options, the doctor only has to advise of the reasonable options. And he is not negligent, and he has no duty to advise on other treatment options, even if other doctors would regard those options as reasonable. So as long as he has in his own mind exercised his judgment and came up with the reasonable options, he only advised on those options and no other options. Clear? Okay, we can come back to this if necessary. That is actually hugely welcome by the medical community. But one thing to bear in mind, and you are warned, those of you who are doctors, McCulloch is not to do with invasive treatment. It is just prescription of medicine. And yet they spring on you Montgomery. In the interest of time, the other case I want to talk about is HQA and Newcastle upon Tyne. When I saw this case, my first reaction was any of my friends affected, because I used to work there? Now, in that case, the reason why about 15 minutes ago, I asked if there are any cardiothoracic surgeons in the audience, the patient suffered from congenital pulmonary atresia. So the pulmonary valve wasn't working properly. And as a result, the patient developed cardiac failure. And importantly, the aortic root was dilated. The aorta is the main artery coming out of the heart. Now, in all of us, the aorta sits behind the sternum, in all of us, at the level of T4, the sternal notch. This is my sternal notch. In performing this operation, the surgeon was drilling into the sternum. Now, in this particular case, the patient's aorta was dilated, so it was pressing against the sternum, and hence, as the surgeon drilled through, there was a particular heightened risk of damage to the aorta. Now, there was something that could have been done, which was to expose the femoral vessels and the femoral artery, I believe, so that in the event of bleeding, they could immediately do a bypass to mitigate the risk of torrential bleeding, cardiac bypass. But they didn't warn the patient of this risk, and they didn't perform this prophylactic procedure, if you like, and the patient did suffer torrential bleeding. Now, in this particular case, they rightly applied Montgomery. This is a risk that the surgeon should have warned, and they regarded the remedial measure as an alternative treatment option, i.e. perform the surgery in a slightly different way, bolting on the additional procedure. And not only that, had they suggested it, what's the big deal in cutting open your groin to be ready to perform bypass? The courts believed the patient would have accepted that alternative. Now, we have seen in a lot of cases where plaintiff tries to allege all sorts of remedial treatments as alternative. Now, that's not always true. But in this particular case, I hate to agree that it is, in a way, performing the procedure differently by having the bypass on standby, and therefore it was a reasonable alternative option that, my God, I've said a lot more than this slide, that they should have warned and the patient would have accepted. In the interest of time, I would only briefly talk about Burke, which is, in short, it says, whilst a patient has the right to self-determination as to what is to happen to his or her body, having said that, is not the same of demanding certain treatments from doctors. It is still up to the doctors to advise, and that the patient cannot demand, insist on certain treatments, especially treatment that is risky and not indicated. The only other point I want to make, well, if I do a good enough job, Gilberto will invite me back and I'll do the rest of the case law, right? The only other case I want to, one final thought I want to share with you is, true story, Montgomery came out in 2015. James Badenoch QC, who was the plaintiff senior counsel, came to Hong Kong in March 2015. I think it was here.
Academy.
Oh, sorry, at the Academy. I had the honor of giving a presentation with Professor Liamak on Montgomery. And after the lecture, I'm dead serious. Professor Liamak came up to me and said, David, we knew it was coming. What she meant was, if you look at the evolution, how the case law was evolving leading up to Montgomery, you could see was going in that direction since Sidaway in 1985. So therefore, it was a matter of time. A court with the right case will decide like Montgomery, and they did. But the medical council, what Professor Liamak meant, and I don't mean to be frivolous, they already saw it coming, and the Medical Council Code amendments in 2011, 12, and 14 came up with provisions which are identical to Montgomery, and they were years ahead. That's what she meant, and it's true. Not only that, nowadays in medical council judgments, you very often see Montgomery being mentioned and quoted. Now, on that, I'm slightly okay with time. May I have the third PowerPoint put up, please?
Good time.
I've been warned I only have 5 minutes before I'm kicked off. Data security, it goes something like this. In order for doctors to do their job, they have to obtain patient data, confidential information, and keep them for continuation of care. And only to keep them as long as necessary. Whilst they keep the records, they have to make sure the records are kept securely as against unauthorized access and loss. So there I have summarized the key provisions from the Personal Data Privacy Ordinance and the Medical Council Code and the Private Healthcare Facilities Ordinance to do with data security. Those are the main provisions. But one thing that puzzled me, if you look at those provisions, they say, yeah, it's important you maintain data secure, but they never said how. Now, this ordinance that came in 7 days ago, called, you can read, Protection of Critical Infrastructure, Computer Systems Ordinance, tells you how to keep data secure. Now, look at the wording of this ordinance again. It is to do with protection of computer systems for the critical infrastructure. Why do we need this ordinance? It is to reduce the risk of cyber attacks to critical infrastructures, that's so as to maintain normal function of the society, putting it simply. Who has the obligation to maintain their computer system securely? They are the critical infrastructure operators. Now, it is well known that healthcare institutions, healthcare systems, nowadays rely heavily on computer systems, then they are always a target for cyber attack. And sure enough, the commissioner let's call it Commissioner for Cybersecurity, has listed healthcare as one of the key industries. And it is anticipated, I anticipate, that the healthcare institutions, especially the big hospitals, are likely to be designated as critical infrastructure operators, CIO, let's call it simply. Now, the commissioner will tell you, will notify you if you are designated as a CIO. And if you are designated, if you are told you are one, you are a CIO. And remember, it's the institution, not the individuals under the institution who has the obligations. But if you are designated, then you have 3 sets of obligations, and you have to comply with them within 1 to 3 months. And simply, and I'll circulate the slides with permission from Gilberto later on. The obligations are, you have to set up a computer security system unit. You can farm it out. You can outsource it. And however, you still need to have an in-house person to supervise, and it's quite onerous. Secondly, and that has to be complied with within 3 months, you have to conduct computer system security risk assessments, audits, and you have to ensure that your third-party providers are also in compliance with the statutory duties. In the event of non-compliance, it is not the third party, but the CIO, let's call it the hospital, who is responsible. The third set of obligations, you are meant to, within 3 months, come up with an emergency response plan. Periodically, you have to undertake security drills, and you are meant to notify the commissioner in the event of data breach. If serious, within 12 hours, if not, then within 24, and to provide a report within 14 days. Just briefly to mention, the penalties are fine and daily fines. Now, in terms of practical steps, and I'll wrap up within a couple of minutes, it is advisable, especially for the bigger healthcare institutions, to look at their existing measures and computer system and compare it with the statutory requirements, and to look for the gaps and consider using resources to fill those gaps. So there are simple things like, do you have strong enough firewall? Do you use strong enough passwords? Do you have a response plan? Do you have filter for scam emails, all the way to more further consideration? Do you have a manager? Do you have a security manager? Do you already perform risk assessments? What is important is to look at your contracts with third-party providers, to make sure that the provisions that you basically put upon them the same statutory obligations, and perhaps put in place penalty clauses to enable back-to-back liability. There is a code of practice, which is extremely useful. It's next to Gilberto. I'm not going to go into the powers of investigation by the commissioner, but you would imagine, there are powers to compel you to give explanation, provide documents, and they have the power to enter your premises to search, and to, well, they can apply for magistracy warrants to search and to preserve evidence. One final point I would like to say is, even if you are not a CIO, it is good practice to adopt or to have reference to the measures suggested under the ordinance. I'm 2 minutes over, and thank you.